Cigna's denial of a dock worker's any occupation or ERISA disability claim upheld by a Florida judge. Now, one of the most dangerous clauses in an ERISA disability policy or plan is something called the discretionary clause. It's a grant of discretion to the disability carrier or to the plan. Let me tell you the story of Collins versus Cigna. It illustrates this problem. It's a Middle District of Florida case. The summary plan description provided that the plan administrator had appointed the insurance company, in this case Cigna, to be the named fiduciary in adjudicating the claims for benefits under the plan, and in deciding any appeals of the denied claim. So the insurance company was to have the authority, Cigna, in its discretion to interpret the terms of the plan to decide questions of eligibility for coverage and, of course, to decide entitlement to benefits and to make any related findings of fact that they needed to make that decision. All of the decisions that were made by the insurance company were to be final and binding on the participants and the beneficiary to the full extent permitted by law. That's a discretionary clause. And as a result, if a claim is denied or terminated, the plan participant has the burden to prove that the disability carrier or plan administrator abused that discretion. Not that they're necessarily disabled, but it is an abuse of discretion, and they acted in an arbitrary and capricious manner. That's an incredibly high burden of proof. And to confer that discretion, a plan document or policy has to have that express language that's unambiguous. And in making this finding, the court has to review all of the plan documents because ERISA law requires that. Now, ERISA law has never created a standard of review. It's a court-created body of law. And it tells the court how they go about reviewing the plan administrator's decision or the carrier's decision in denying or terminating benefits. The courts generally have held that a denial of benefits is to be reviewed under a de novo standard, a fresh set of eyes, if you will, unless the benefit plan gives the administrator or fiduciary that discretionary authority to determine eligibility for benefits or to construe the terms of the policy or the plan. Now, each federal circuit, unfortunately, has their own framework for analyzing an ERISA disability benefit denial or termination. They have their own standard of review. Now, that's why it's important, in my view, to have a complete copy of the plan or policy and the summary plan description so you can understand what the applicable standard of review is based on, of course, what particular circuit you're in. Now, that plain language that I just cited to you was clearly arbitrary and capricious. It wasn't de novo. And unfortunately, we're in the 11th Circuit. And the 11th Circuit has a very convoluted standard of review under the arbitrary and capricious standard of review. And they can't substitute, the judge can't substitute their own judgment for that of the plan. So they have to go through this test. Now, Mr. Collins was employed as a dock worker, a heavy, obviously, occupation. And he was required to lift as many as 100 pounds constantly while moving and handling materials. He stopped working in 2019 because of spinal and orthopedic injuries caused by 2 automobile accidents. Cigna paid Collins his own occupation long-term disability benefits, but when the definition of disability changed to an inability to do any occupation by, that he might have been eligible to perform based on his past occupational history, Cigna said, look, we think you can work in a sedentary position. Now, this was a dock worker who had never worked in a sedentary position. Cigna's doctors concluded that Collins could sit constantly for at least 30 minutes at a time for up to 6 hours a day with the ability to frequently change positions every half hour, with a 2-minute stand and stretch break. Cigna then had a transferable skills analysis performed that said this dock worker had vocational skills to perform sedentary work. Ultimately, of course, he contests their argument that he could be a surveillance system monitor or an information clerk. And ultimately, of course, the case is denied, ends up in front of a federal judge in the Middle District. What was the kiss of death? Well, unfortunately, the kiss of death was that standard of review. And the court said, look, our hands are bound. We have to use this arbitrary and capricious standard of review. We can't substitute our own judgment. And ultimately, of course, the court cited evidence supporting Cigna's rationale for denying the claim, including its rejection of his treating physician's opinion about his restrictions and limitations, and rejecting the vocational evidence that he had submitted. Under the ERISA law, the court doesn't have to give special deference to the opinion of a treating physician. And that means that the disability carrier can choose who they want to believe. And of course, who do they believe? They believe their own doctors. Ultimately, of course, the court upholds this denial on the basis that it wasn't arbitrary and capricious, that they had the right to select who they were going to believe in terms of medical opinions and the vocational evidence. And in doing so, they weren't arbitrary and capricious. You could see, even though it doesn't make sense that a dock worker could potentially do sedentary work, the court ultimately upheld this denial based on that arbitrary and capricious standard of review. If you have any questions about your rights to disability benefits, regardless of where you live in the United States, call me today at 727-894-3188 for a complimentary consultation. I can help you get the disability benefits you deserve, regardless of where you live in the United States.